Hi, my name is Stewart. I'm an attorney from Northern California, and my practice focuses on business law, estate planning, and intellectual property. Today I'd like to talk to you about the general documents that come with an estate plan. Obviously, your situation is going to be different from anybody else's, and it can change frequently, but usually when attorneys talk about an estate plan, they mean certain documents that will go together. The centerpiece of your estate plan, in California at least, will likely be a revocable trust. As I talked about in another blog, it's a very good idea to set up a revocable trust because you can avoid probate that way. So a lot of your assets will go inside of it. It will also be the most dispositive instrument in your estate plan. It's going to basically tell your trustee, the person that administers your trust for you after you pass, what should be done with the property inside of it. In addition to that centerpiece, which is your estate plan, outside of it you should also have a will. Just because you have your revocable trust doesn't mean you shouldn't also have a will. Because the way that it'll work is you'll have certain assets inside of your trust, but it'll be easier to have certain outside. For instance, a bank account is probably less than $150,000, which is the cutoff for probate purposes. So keep your bank account, your checking account at least, outside of your trust. But at the time of your passing, the trust only controls what's inside of it. So you have to have an instrument that is going to take everything outside and put it into the trust, which will then determine how things go. That's called a will, or more particularly, it's called a pour-over will. The other two important documents that you should have with your estate plan are two durable powers of attorney. One of them will be a durable power of attorney for healthcare matters, also called an advanced healthcare directive, and the other will be a durable power of attorney for general matters or financial matters. These are incredibly important even if you're a younger person because they can come into effect at the moment of your incapacity. So unlike a trust and a will, which take effect, or rather are most important at the time of your death, although a trust is still a live document, a durable power of attorney is incredibly important to have while you're alive. There is no more durable power of attorney after you pass. Everything is administered through your trust and your will. So the durable powers of attorney are when you can't make a decision for yourself because you're incapacitated, but you need to have somebody you can trust to do so. Advanced healthcare directives are also very important because in addition to granting your agent the power to make a decision for you, you can also spell out what you would like to happen in certain situations. So nobody has to guess as to what your wishes are for medical care. If you have any more questions about what these documents entail and how it would apply to your specific situation, feel free to call me at my law firm or to email me through my website. Thank you.